Joining us is Christopher Green, law professor, Professor Green, University of Mississippi, the current holders of the Egg Bowl Trophy. I know that they would want me to throw that in. The state of Mississippi's case against the Tennessee over the water rights. Good morning, Professor. How are you, sir?
Good morning. Good morning. We lost pretty bad in the water case.
Yeah. Was there ever a chance, a reasonable chance, of the court really going the way we wanted it to go, though?
So this is an old case, and the idea that we had was that this aquifer, this huge aquifer under 8 states, the part that's under Mississippi is just our water. So the argument was not that Tennessee or Memphis was taking too much. The argument was they're not allowed to take it at all. And the court thought that can't be right because you're taking some of the water that's been in Tennessee, even though you're drilling straight down, it's moving around. So the argument that, once you find an aquifer that's under more than one state, you have to have an interstate compact. That's essentially what we were arguing. That did not fly. So,
had it been
Ole Miss versus Tennessee worked out better than the state versus state.
True. Had it been a contained lake within the confines of the boundary of the state of Mississippi, that would have been another subject. But I mean, it's almost like saying somebody in Tennessee or above in Memphis or Missouri cannot take water from the river, Mississippi River. That wouldn't work out.
That's essentially what they said. They said they never had a case specifically about underground aquifers saying exactly that we treat them like a river, but this gave them the occasion to do that, to say an underground aquifer is treated like a river, which means you are allowed to sue about apportionment, and you can say, hey, they're taking too much, but we specifically said in our lawsuit, we don't want that. So we actually lost even worse than we did before the special master. The special master said, well, if you want to ask for apportionment, go ahead. And the Supreme Court said, well, you disavowed that, so you're not going to be able to do that. So they said, we have the suit dismissed with prejudice. We can't even refile it. But we obviously could file a separate lawsuit about apportionment, but it would be based on a different theory.
Was there ever a time, Professor Green, where we had a shortage because of, at least that we pointed to the Memphis usurpation because of that? Was there ever a time that we came up short with water or had some problems that you know of in the suit?
I haven't really followed the details of the hydrology. I gather that there are some issues not just with raw amounts of water. So the idea that we wouldn't get able to take enough water, but there was an argument that there were some geological impacts. So because so much water is getting taken out right next to the border, there were some just geological issues with the quality of water or something like that. But it's nowhere have nothing like the scarcity you have out west. So Chinatown, you get whole plots of movies about water rights. I don't think this is going to be a movie.
Wasn't Yellowstone. We never had a situation where Memphis they were actually drilling in Mississippi territory, as far as I know. Were they?
No, they were going straight down. But our theory was when you go straight down, they're taking our water. But, of course, we're taking their water, some of it, because it's sloshed around. I mean, the aquifer, the biggest part of it is under Mississippi. But that fact didn't really make any difference.
Look, I would love to have won just because it's Mississippi and that's Tennessee. But it just seems strange to spend legal time on something like that. I never understood it. Can we talk a little bit about the abortion case coming up on Wednesday?
Sure.
And what's going to happen then? Wednesday this week. That's all right. It is a question, and tell me what you think about it, what your outlook is, and I also want to think. Let me go over, maybe because we have limited time here. Let me ask you how you think maybe some of the judges, and let's take Chief Justice John Roberts first of all. What do you think his views are going to be on this?
It's hard to tell. So when his Sela Law, or his opinion in June Medical, rather, came out in the summer of 2020, a lot of people, I was immediately looking at it thinking, well, do you agree with Roe and Casey or not? And it was very hard to tell. He ended up relying on stare decisis for this 2016 case, but then overruling that same case in another respect. So it was cutting it really, really thin. He didn't specifically reaffirm it. He didn't say the due process clause or some other clause of the 14th Amendment applies and protects abortion rights. So it's certainly, the door is certainly open for him to say Roe and Casey were wrong on the days they were decided.
So
it's very hard to tell.
So you put him on the can't decide how he's going to do it list. Justice Clarence Thomas, I think that's a different case there. We kind of know where he's going to go on this.
Yeah, in Casey itself, in 1992, he was only on the court a year, but he made very clear that Roe was wrong, sufficiently clearly wrong, that he should overrule it. He's actually even developed his views since then and made a more emphatic statement that if you have demonstrably erroneous precedent, that's the standard you should use for when you overrule it. And I think, I think there's just no question. One issue is the extent to which the other justices who have said some things, of varying levels of clarity about precedent since then, what they'll do. Justice Barrett, she wrote about precedent a lot as a professor. So she, I think, has said things that are certainly consistent with Justice Thomas's view that if you know that a precedent is wrong, she says you don't always have to reconsider it. But once you reconsider the issue, the issue is before the court, if it is clearly wrong, then you have to say what the Constitution actually means. And it certainly seems like from various bits of her writing that she would be inclined to think Roe was and Casey were incorrectly decided. But the time you have a moving target because reliance interest, how much people have relied on the case is constantly changing. So it's a slightly different question now than it was in 1992. But the fundamental issues haven't really changed that much. Are the visibility of it with technology has changed a bit. What viability is with medical technology changes a bit. But the basic issues about, should you have a line that depends on medical technology? Yeah. Justice O'Connor was making those points in the 80s. And I don't think the basic argument really has changed since 1973.
Some of the words of Justice Thomas said, nothing in our federal Constitution deprives the people of this country of the right to determine whether the consequences of abortion to the fetus and to society outweigh the burden of an unwanted pregnancy on the mother. Although a state may permit abortion, nothing in the Constitution dictates that a state must do so. The words of Clarence Thomas. And as much as we see that as a vote for the pro-life sector, I think on the other side, Sotomayor and Kagan were pretty locked in as far as voting against this, wouldn't you think?
Yeah, certainly the way that they have voted so the Whole Woman's Health case from 2016 and then the June Medical case from 2020, both of those justices, Justice Breyer, I think it's pretty clear they're going to want to reaffirm Casey much more energetically. But it's not clear exactly how they're going to do it, and